Disclaimer. Educational content, no legal or career advice. 1. For educational purposes only, the content presented in this video, How to Study Law Effectively, is strictly for informational and educational purposes only. The tips and strategies shared reflect the creator's personal research and opinions and should not be interpreted as professional advice. 2. No attorney-client relationship. Important. Viewing this video, subscribing to the channel, or interacting in the comments section does not create an attorney-client relationship between you and the creator. The creator is not your attorney and is not providing legal services or representation. 3. Not professional advice, legal or career. The creator is not a licensed attorney, career counselor, or academic advisor. This video does not constitute legal advice or professional career guidance. Do not act upon any information in this video without seeking advice from a qualified attorney, professor, or academic counselor suited to your specific situation. 4. No guarantees of success. We make no representations or warranties regarding your academic performance, exam grades, bar exam results, or future career/financial success based on the information provided. Studying law is a complex process, and results vary significantly by individual. 5. Limitation of liability. You are responsible for your own academic and life decisions. The creator assumes no liability for any errors, omissions, or damages resulting from your reliance on the information contained in this video. There's a moment that hits every first-year law student. For me, it was about 3 weeks in. I was in the law library, a place so quiet you could hear a textbook weep, and I was surrounded by a fortress of casebooks. Each one was a brick thick and heavy, filled with dense, archaic language about contracts and torts and something called civil procedure. I had 1,000 pages of reading to do before my classes the next week, and I had already spent 8 hours that day just trying to get through 100. A cold, creeping panic started in my stomach. It wasn't the kind of stress you get from a tough undergrad exam. This was different. This was a deep existential dread, the dawning realization that I might not be smart enough, that I might not have what it takes, that I had made a colossal 6-figure debt mistake. Maybe you're feeling that right now, or maybe you're about to start law school, filled with excitement, and you can't even imagine that feeling. Trust me, it's coming. And that moment, that feeling of being completely and utterly lost in a sea of information, is the first great filter of law school. It's where so many brilliant people decide to quit. But what if I told you that feeling isn't a sign that you're not cut out for this? What if I told you it's actually a symptom of a much bigger problem, a problem that has nothing to do with your intelligence and everything to do with your method? The single biggest lie we are told before law school is that it's just like college but harder. More reading, more writing, more stress. That's not just wrong, it's dangerously wrong. It's like telling a swimmer that deep-sea diving is just like swimming but deeper. It completely ignores the fact that you need entirely new equipment, a new way of breathing, and a new understanding of the crushing pressure around you. The study habits that got you an A in undergraduate history or political science, the highlighting, the rereading, the flashcards with simple definitions, those are the very habits that will drown you in law school. Why? Because law school isn't about memorizing facts. Nobody cares if you can recite the holding of Marbury v. Madison from memory. A paralegal can look that up in 10 seconds. Law school is about learning a new way to think. It's about deconstructing an argument, identifying the core issue, applying a complex rule to a messy set of facts, and then constructing your own logical, persuasive argument. You are not being trained to be a legal encyclopedia. You are being trained to be a legal analyst. You are learning the process, and you cannot learn a process through passive review. Think about it. Could you learn to play the guitar by just watching videos of Jimi Hendrix? Could you learn to bake a perfect sourdough loaf by just rereading the recipe a dozen times? No. You have to pick up the guitar and make your fingers bleed. You have to get flour all over the kitchen and create a few rock-hard, inedible bricks. You learn by doing. You learn by struggling, by failing, and by actively engaging with the material. Yet, what do most law students do? They spend 90% of their time on the most passive, least effective activity imaginable: reading. They sit in the library for 12 hours a day, dutifully reading and highlighting every single word, convincing themselves that because they're putting in the hours, the knowledge must be seeping into their brain through sheer osmosis. It's not. Highlighting a casebook is the academic equivalent of tricking your brain into thinking it did something useful. It feels productive, but it produces almost zero long-term retention or, more importantly, understanding. Rereading your notes is just as bad. It creates a dangerous illusion of mastery. The material looks familiar, so you think you know it. But familiarity is not competence. So what's the alternative? How do the students who finish in the top 10%, The ones who get the prestigious journal positions and the six-figure job offers right out of the gate do it. Do they have photographic memories? Are they just geniuses who were born to do this? Absolutely not. I knew plenty of people who were far smarter than me, people with perfect LSAT scores, who struggled mightily because they couldn't break their old habits. The secret isn't raw intelligence. It's the system. Top law students understand that studying law is a skill. And like any skill, it can be learned and optimized. They trade passive review for active engagement. They treat every study session not as a time to absorb information, but as a time to solve problems. They spend less time reading and more time doing. They understand the 80-20 principle, that 20% of their effort focused on the right activities will produce 80% of their results. This video is that 20%. I'm going to give you the 5 core pillars of that system. These aren't just little hacks or tips. These are fundamental shifts in your approach that will transform you from a passive information consumer into an active legal problem solver. This is the roadmap I wish someone had given me during that panic attack in the library. This is how you stop drowning and start swimming. The foundation of this entire system, the principle that every single one of our 5 tips is built upon, is this: your goal is not to learn the case. It is to extract the rule. That's it. That's the whole game. Every case you read, from a 200-year-old property dispute about a fox hunt to a modern-day Supreme Court decision on digital privacy, was put in your casebook for one reason and one reason only. It stands for a legal rule. The story is just the wrapping paper. The facts, the quirky details about the plaintiff and the defendant, they are merely the context that helps you understand how that rule works in the real world. The mistake 99% of students make is that they get bogged down in the story. They spend hours trying to memorize the intricate details of Palsgraf v. Long Island Railroad Company, the man with the package, the fireworks, the falling scales. And they completely miss the point. The point isn't the fireworks. The point is the legal principle of proximate cause and the zone of danger. Your professor isn't going to ask you, what color was Mrs. Palsgraf's hat? They are going to give you a completely new set of facts, a different person, a different accident, a different injury, and ask you to apply the rule from Palsgraf. If you spent all your time memorizing the story, you're toast. But if you spent your time extracting the rule and understanding its logic, you're ready to think like a lawyer. So, from this moment forward, I want you to change your entire mindset. When you open your casebook, your mission is not to read. Your mission is to be a detective. You are hunting for one thing, the rule. Everything else is just a clue. This single mental shift is the key that unlocks everything else. It's the difference between being a law student and a student who studies law. It sets the stage for our very first and arguably most important tip, which is this: stop reading cases like a novel and start dissecting them like a surgeon. This is tip number 1, read for the rule. This sounds simple. Sounds obvious. I promise you it is the single most violated principle in all of law school. And it's the primary reason so many brilliant students burn out in their first semester. Let me take you back. It's my first year. Contracts class. The reading list looks like a phone book, and the first case is some dusty old English decision from the 1800s. It's called Hadley versus Baxendale. The story is about a crankshaft from a flour mill that breaks. The mill owner, Hadley, gives the broken shaft to a shipping company, Baxendale, to take to a manufacturer for a replacement. But the shipping is delayed. The mill stays closed for days longer than it should have, losing profits. Hadley sues Baxendale for all those lost profits. Now, my first-year brain read this and I got lost in the details. I was picturing the 19th century mill. I was imagining the frustrated owner, the dusty flour everywhere. I was trying to understand the mechanics of a steam engine crankshaft. I spent hours trying to memorize the facts, the names, the dates, the sequence of events. I filled pages of my notebook with a detailed narrative. I went into class feeling like I knew that case inside and out. And then the professor, a terrifyingly sharp woman who we all called the Shark, cold called me. "Mr. Davis," she said, her voice cutting through the silence of the lecture hall. "State the rule in Hadley v. Baxendale." And I froze. I just stared. My mind was a complete blank. I could have told her the name of Hadley's dog if it had been in the opinion, but the rule? I stammered. I started retelling the story. Well, there was a mill, and the crankshaft broke, and the delivery was late. She cut me off. I didn't ask for the story. I can read the story. I asked for the rule. What is the legal principle that this case gives us? The silence was deafening. I felt my face turn hot. After what felt like an eternity, She moved on to someone else, who correctly stated the rule. A party breaching a contract is only liable for damages that were reasonably foreseeable to both parties at the time the contract was made. That moment of humiliation was the most valuable lesson I ever learned in law school. I had spent 3 hours reading a 10-page case and had completely missed the only sentence that mattered. I was reading for the story. I was treating it like history. But a case is not a story. It's a delivery mechanism for a single precious piece of cargo. The rule of law. The facts, the broken crankshaft, the delayed delivery. They are just the wrapping paper. They are the context that helps you understand the rule, but they are not the point. Your job as a law student is to tear off the wrapping paper, find the prize inside, and put it in your toolkit. So how do you do this? How do you retrain your brain, which has spent 20+ years learning to read for plot and character, to instead read for the rule? It's a 4-step process. First is the pre-read. Before you dive in, spend 60 seconds orienting yourself. Don't start on page 1, word 1. Skim the case first. Who are the parties? The plaintiff and the defendant. What is the basic nature of the dispute? Is it a car accident? A broken contract? A criminal charge? What court is this? Is it a trial court or an appellate court? Just get the lay of the land. This initial 60-second investment prevents you from getting lost in the weeds later. You're building a mental map before you venture into the jungle. Second is the active hunt. Now, you begin reading the case from the beginning, but you are not a passive reader. You are a hunter. And you are hunting for one thing, the rule. You should have a highlighter or a pen in your hand, and your entire brain should be focused on a single question. Where is the sentence or the 2 sentences, where the court announces the legal test it is using to solve this problem? You are actively scanning for it. Ignore the long-winded procedural history. Skim past the detailed recitation of facts you already know from your pre-read. You are looking for judicial language. Phrases like, "We hold that," or "the correct standard is," or "in order for a plaintiff to prevail, they must show." These are giant, flashing neon signs that say, "The rule is here." When you find it, you capture it. Underline it. Highlight it. Put a big star next to it. This is your trophy. The third step is to isolate and analyze. Once you've found the rule, write it down on a separate document or in the margin of your book, completely divorced from the facts. Look at it. This is the pure, abstract legal principle. In Hadley, it's the foreseeability rule. Now look at its components. What are the pieces? For a defendant to be liable for special damages, those damages must be 1. Foreseeable and 2. Communicated to the defendant. You break it down into its elements. This is the process of legal dissection. You are taking the machinery of the law and figuring out how the gears fit together. The fourth and final step is the most critical, paraphrase. Now take that rule you've written down and broken apart, and explain it in your own words. Simple words. Imagine you have to explain it to your friend who isn't in law school. If you can't do that, you don't truly understand it. If you find yourself just regurgitating the court's legalese, heretofore the aforementioned party of the first part, you haven't learned it. You've only memorized it. Memorization is fragile. Understanding is permanent. So for Hadley, you might say, look, you can only sue someone for damages they should have seen coming when you made the deal. That's it. That's the rule. By forcing yourself to translate it from legalese into plain English, you are forging a permanent neural pathway in your brain. You now own that rule. It's not just something you read, it's something you understand. This 4-step process, pre-read, hunt, isolate, and paraphrase, transforms reading from a passive, time-consuming chore into an active, efficient, and incredibly effective mission. You will cut your reading time in half, and your comprehension will skyrocket. You'll go into class not with a head full of stories about broken machine parts and angry millers, but with a clear, concise understanding of the legal principle at stake. You'll be ready for the shark. This first tip is the foundation for everything else. Because law school isn't about collecting stories, it's about collecting rules. Each case you read is a chance to add one new rule to your mental toolkit. By the end of a semester, you'll have a toolkit filled with hundreds of these rules, rules about negligence and contracts and criminal intent. But collecting the tools is only the first step. A pile of wrenches and screwdrivers on the floor isn't a workshop. It's a mess. The next challenge, and the one that separates the A students from the B students, is figuring out how to organize that toolkit so you can find the exact right rule at the exact right moment. How do you build the mental framework to house all this knowledge? The answer is deceptively simple, yet profoundly powerful. You build an outline. This is the first major tip, the bedrock on which all other effective study habits are built. Master the art of the outline. Now, when I say outline, I need you to erase the image you might have from college or high school. We're not talking about a simple list of bullet points you jot down before writing an essay. A law school outline is something entirely different. It is a living document. It is the architectural blueprint of an entire subject. It is the custom-built mental palace you construct, brick by brick, throughout the semester, designed for one specific purpose: to store, organize, and retrieve complex legal rules under extreme pressure. The mistake most struggling students make is thinking that the goal is to have an outline. They beg upperclassmen for their old ones, they buy commercial outlines, they think the finished document is the prize. But they're wrong. The prize, the real learning, the deep synthesis that separates the top students from everyone else, is in the act of creating it yourself. Watching someone else lift weights won't make you strong. Using someone else's outline won't make you smart. So, why is this process so critical? First, it forces synthesis. Your casebook is a chaotic jumble of hundreds of cases. Your lecture notes are a stream of consciousness from your professor. A statute is a dense block of legislative text. They are all just raw materials. Outlining is the process of taking all that raw ore and smelting it down, extracting the pure essential rules, the black letter law, and then forging them into a coherent, logical structure. You are forced to ask, how does this case about a snail in a ginger beer bottle relate to the case about the exploding package on the train platform? You discover the answer is that they both illustrate different facets of the same core principle, like duty or proximate cause in torts. You are building the connections yourself, and that's what makes them stick. Second, it builds the big picture. Day to day in law school, you're in the trenches. You're focused on the facts of a single case, the wording of a single statute. It's incredibly easy to lose sight of the forest for the trees. Your outline is your satellite view. It forces you to zoom out and see how the entire doctrine fits together. You see that contract formation is the first major branch, and under that you have the branches of offer, acceptance, and consideration. And under offer, you have sub-branches for what constitutes an offer versus a mere invitation to treat. You start to see the subject not as a list of 1,000 random rules, but as a logical hierarchical system. This mental map is invaluable on an exam when you need to quickly identify which area of the law a particular fact pattern implicates. So, how do you actually do it? This isn't a mystical art. It's a discipline, and it starts from day one. Do not wait until the reading period before finals to start your outline. That is the single most common and catastrophic mistake a first-year law student can make. Trying to synthesize 14 weeks of complex material in 7 days is like trying to build a skyscraper in a week. It will be a mess and it will collapse. Instead, you start in week 1 or 2. Your syllabus is your guide. Your professor has already given you the skeleton of your outline. It's the table of contents for the course. If the first topic on the syllabus is personal jurisdiction, then the first Roman numeral in your outline is I, personal jurisdiction. Then you work on it every single week. Set aside 3 or 4 hours every Saturday or Sunday. Your only goal during that time is to take the material from the past week, the cases you read, the notes you took in class, and integrate it into your outline. Let's say this week in civil procedure, you covered specific personal jurisdiction. You read 3 key cases. Your job is not to write a long, rambling summary of each case in your outline. Your job is to extract the 1 or 2 key legal rules or tests that each case stands for. For instance, after reading International Shoe v. Washington, you don't write 2 pages about the facts of the case. You go to your outline under I, personal jurisdiction, then maybe B, specific jurisdiction, and you write the rule. For a state to have specific jurisdiction over a defendant, the defendant must have sufficient minimum contacts with the forum state such that the suit does not offend traditional notions of fair play and substantial justice. That's the gold. Then you might add a subpoint. This test balances the defendant's purposeful availment and the reasonableness of the suit. Then, as a final note, you simply cite the case. Asterisk International Shoe asterisk. The case name becomes a trigger, a mental shortcut. You've already briefed the case and discussed it in class, so you know the story. In your outline, it serves only as an illustration of the rule. The rule is the star of the show. Your outline should be a document of rules, not a collection of case stories. As you add new material each week, you'll be forced to organize it. You'll ask yourself, okay, the professor just taught us about the stream of commerce theory. Where does that fit? you'll realize it's a specific way of analyzing purposeful availment, which is part of the minimum contacts test. So you slot it in right there. This weekly process of organizing and reorganizing is an active form of learning. It's a mental workout. You are constantly reinforcing the structure of the law in your mind. This brings me to the next fatal trap: relying on commercial outlines. It's so tempting. You see these glossy, perfectly formatted books from companies like Barbary or Emmanuel, or you get a digital outline from a well-meaning 2L. You think, great, the work is already done for me. This is a siren song. The value of an outline is not in the finished product. It is in the intellectual struggle of its creation. Forcing your brain to condense, categorize, and structure the information is what builds the neural pathways you need for rapid recall during an exam. Using someone else's outline is like trying to navigate a city using a map drawn by another person of a route they took. You don't actually learn the streets. Building your own is like driving every street yourself, day after day, until the map is burned into your memory. Now, that doesn't mean those other outlines are useless. They can be a fantastic resource. Use them as a reference. After you've built your own section on, say, the duty element of negligence, pull out the commercial outline and compare. See if you missed a key rule. See if they structured it in a way that makes more sense. Use it to check your work, to fill in gaps, but never, ever use it as a substitute for your own intellectual labor. The final element of a great outline is ruthless condensation. Your goal is not to create a 150-page treatise that includes every word your professor ever said. Your goal is to create a functional tool for an open book exam. It needs to be lean, clean, and fast to navigate. As you approach the end of the semester, you should be constantly trimming the fat. Can you say that rule more concisely? Is that case example really necessary? Or do you know it cold? Many students even create a short outline or an attack outline, a 5 to 10 page hypercondensed version that is just a checklist of issues and key rules. This is your cockpit checklist for the exam, helping you spot every single issue in the fact pattern. By the time you walk into your final exam, your self-made outline is more than just a stack of paper. It's a testament to a semester of hard, consistent work. You know every inch of it because you are its architect. You built it from the ground up. This document, this framework you've constructed, is the physical manifestation of your understanding of the law. You've tamed the chaos. You've turned a fire hose of information into an organized toolkit, with every rule in its proper place, polished and ready to be deployed. But having the perfect map is one thing. Knowing how to read it under fire, how to navigate its terrain when the clock is ticking on a 3-hour exam, that's a completely different skill. And that brings us to the single most misunderstood practice in all of legal education: the dreaded, the revered, the almost universally misused practice of briefing cases. Yes, case briefing. I can almost hear the collective groan from every 1L and pre-law student watching this. It's the first real lawyerly thing you're taught to do, and for most it becomes an absolute time-sucking nightmare. You're handed a casebook the size of a cinder block, filled with dense, jargon-laden judicial opinions from the 19th century, and you're told to brief every single one. So what does the typical student do? They follow the formula they're given with painstaking precision. They open a fresh Word document. They type out facts. They spend the next 45 minutes trying to summarize a convoluted story about a railroad and a misplaced package in their own words. Then they type procedural history and spend another 20 minutes tracing the case's journey through the court system. Then issue, holding, reasoning. 2 hours later, they emerge bleary-eyed with a beautiful 3-page, single-spaced summary of one case. They print it out, place it lovingly in a 3-ring binder, and feel a profound sense of accomplishment. They've done the work. They're a real law student now, and they have just wasted 2 hours. That binder, my friends, is the graveyard of good intentions. It is a monument to inefficiency. Because here is the secret that your professors might not tell you, and that you usually only figure out after your first semester grades come back with a thud. The point of briefing a case is not to create a perfect, detailed summary of that case. The physical brief itself is almost worthless. Let me say that again. The document you spend hours creating is not the point. The point of case briefing is not the noun, the brief. It's the verb, the briefing. It is a mental exercise. It's reps for your brain. It is the act of performing an intellectual autopsy on a judicial opinion to train your mind to spot the legally significant parts. That's it. The goal isn't to produce a document for your binder. The goal is to rewire your thinking, so you can read and analyze legal text with the speed and precision of a lawyer. The brief is just the disposable training equipment you use to build that mental muscle. Once you understand this, everything changes. The entire process transforms from a tedious clerical task into a strategic, high-impact training session. This brings us to the second pillar of effective law school study. Brief for the brain, not for the binder. So what does this look like in practice? It means you abandon the formal multi-page Word document. You close the laptop, you pick up a pen, and you engage directly with the text in your casebook. This is often called book briefing or marginalia, and it is, without a doubt, the single most powerful and efficient way to prepare for class. Here's how it works. Instead of creating a separate summary, you create the summary inside the book itself. You're going to use a system of highlights, underlines, and notes in the margins to deconstruct the case right there on the page. You're not rewriting anything. You're isolating and labeling the essential components. The most common framework for this is, of course, IRAC: issue, rule, application, and conclusion. But we're not going to write those words out. We're going to use them as a mental checklist as we read. First, the facts. You don't need to rewrite the story. Your only job is to identify the legally relevant facts. These are the specific facts the court relied on to make its decision. Most of the story is fluff. Is it important that the plaintiff was wearing a blue hat? No. Is it important that he crossed the street outside the designated crosswalk? Absolutely. You take a highlighter, let's say yellow, and you highlight only those key outcome determinative facts. A sentence here, a phrase there. That's it. Your facts section is done. Took you maybe 2 minutes. Next, the issue. This is the legal question the court is trying to answer. It's often explicitly stated, sometimes phrased as the question before us is, or we must decide whether. Find that sentence. Put a big question mark next to it in the margin, or write the word issue. Circle it. You've now identified the core question of the entire case. Done. 30 seconds. Then comes the most important part, the rule. This is the black letter law the court announces or applies to answer the question. This is the golden nugget. This is the piece of the puzzle you will take with you and put into your outline later. It's the principle that will apply to future cases. Find the sentence or paragraph where the court says, the rule is, or lays out a specific legal test. Underline it. Maybe twice. Put a star next to it. Write rule in the margin. This is the heart of the case. After the rule comes the application or the analysis. This is the why. It's the court's reasoning. How did it apply that rule to the specific facts you highlighted earlier? This is usually the longest part of the opinion. You don't need to capture all of it. You're looking for the logical steps. Maybe you use a different color highlighter, say green, to trace the court's logic. Or you can simply bracket the entire section and write analysis or reasoning in the margin. You're just flagging it so you know where the court explained its thinking. Finally, the conclusion or the holding. This is the court's direct answer to the issue. It's the outcome. Who won? Who lost? It's usually found at the very end. We therefore affirm the lower court's decision, or we reverse and remand. Box that sentence. Write holding. Done. The entire process for a standard 10-page case should not take you more than 15 to 20 minutes. Compare that to the 2 hours you were spending before. You have accomplished the exact same intellectual task, identifying the key components of a legal opinion, but you've done it in a fraction of the time. And here's the beautiful part. When you get cold called in class and the professor asks, Miss Smith, what was the rule in Hawkins v. McGee? You're not frantically flipping through a binder of dense paragraphs you wrote 3 nights ago. You are looking at the casebook. Your eyes go directly to the double underlined sentence with the star next to it. The information is right there, in its original context, perfectly isolated and ready for you to articulate. You're not just prepared, you look like a star. This method does more than save time. It forces you to engage with the text on a deeper level. Writing a separate summary allows for a certain passivity. You can transcribe without truly understanding. But when you're forced to make decisions on the page, to decide which sentence is the rule, which fact is the most important, you are actively analyzing as you read. You are building the mental muscle. You are briefing for your brain. The binder of typed briefs makes you feel productive. The book briefing method makes you productive. It frees up hundreds of hours over the course of a semester, hours that are far better spent on the one activity that actually determines your grade, the one activity that all this case reading is supposed to be preparing you for. And that is the art and science of building your outline. Because reading and understanding individual cases is like collecting individual bricks. It's a necessary first step, but it's not the goal. A pile of bricks won't protect you from the storm of a final exam. You have to take those bricks, those rules you've extracted from each case, and build them into a coherent logical structure. You have to build a fortress. That fortress is your outline, and it is the single most important document you will create in law school. All of this case analysis, all this marginalia, is useless if it just stays scattered across 1,000 pages of your casebook. You need a system to synthesize it, to see the connections, to understand the bigger picture. This is where you transform from a student who knows the cases to a student who understands the law. And this is where you start to win. So let's talk about how you win. Winning in law school and in law itself isn't just about having the sharpest sword. It's about having the best map of the battlefield. You can have 100 perfectly briefed cases, 100 sharp little swords, but if you don't know how they fit together, if you don't understand the terrain, you'll be lost. You'll swing wildly and hope for the best. That's what most first-year law students do. They walk into an exam with a bag full of individual case facts and they just dump them onto the page. But the A student, the student who wins, walks in with a blueprint. They see the entire structure. They know how the foundation of contract formation supports the walls of breach and how that connects to the roof of remedies. They have a map. And that map, that blueprint, is your outline. This brings us to our second critical tip. You must master the art of the outline. Now I know what you're thinking. Outlining? Really? That's the big secret. You've been outlining since middle school. You outlined your history paper on the American Revolution. This sounds basic. And that, right there, is the most dangerous misconception in all of law school. A law school outline is not a study guide. It is not a list of things to memorize. The finished document, the 50-page Word file you slave over, is almost worthless. Let me say that again. The piece of paper itself is not the point. The process of creating it, that is everything. The act of outlining is the single most important intellectual exercise you will perform in law school. It is the mental gym where you build the muscles of legal analysis. It's where you take all those individual bricks, those case briefs we just talked about, and you force them piece by painstaking piece into a coherent logical structure. The number one mistake I see students make is they try to shortcut this process. They'll get a hand-me-down outline from a 3L. Or they'll buy a commercial outline from a big company, and they'll read it, they'll highlight it, they'll even memorize it, and they will get a B-, maybe a B if they're lucky. Why? Because they skipped the workout. They tried to get the muscles without lifting the weights. They looked at a picture of a house and thought they understood architecture. Reading someone else's outline is like watching a video of someone else running a marathon. You see the result, but you gain none of the strength, none of the endurance, none of the grit that came from the thousands of miles they put in to get there. The value isn't in the product. It's in the struggle of production. So how do you do it right? How do you build this blueprint from scratch? First, you start with the skeleton. Don't even look at your notes yet. Open up your syllabus. Your professor gave you the map on day one. It's the table of contents for the course. That is your highest level structure. For torts, it probably looks something like this: Roman numeral 1, intentional torts; Roman numeral 2, negligence; Roman numeral 3, strict liability. Simple. That's your foundation. Now, under each of those, you fill in the next layer from the syllabus. Under intentional torts, you'll have capital A, battery; capital B, assault; capital C, false imprisonment, and so on. You are building the frame of the house before you even think about the furniture. Now you start putting up the drywall. This is where you define the black letter law. You go to your notes, your casebook, maybe a supplement, and for each and every subtopic you write down the rule. The crisp, clean legal rule. So under battery, you write out the elements. 1. An act by the defendant. 2. Intent. 3. That results in harmful or offensive contact with the plaintiff. You are not using cases yet. You are defining the pure, abstract legal principles that govern this area of law. This is the logic, the code that the entire system runs on. Only now, after you have the skeleton and the rules, do you bring in the bricks. You bring in your case briefs. This is the magic step. Every case you read was assigned for a reason. It's not just a story about a clumsy smoker on a train platform, or a boy pulling a chair out from under his aunt. Each case is there to illustrate, to explain, or to complicate one of those rules or elements you just wrote down. Your job is to figure out where each case fits. It's a puzzle. You look at the famous case of Garrett v. Daly, the one with the 5-year-old kid in the chair. Where does that go? It's a battery case, so it goes under battery. But where specifically? The court wasn't debating whether pulling a chair was an act. It wasn't debating whether falling was harmful contact. The entire legal fight was about the second element: intent. Could a 5-year-old have the necessary intent to commit a battery? The court said yes, because intent doesn't just mean you wanted to hurt someone. It can also be established if you have substantial certainty that your act will cause the contact. Boom! You just connected a story to a principle. So under your element 2 intent, you indent and write. Intent can be established by showing the defendant acted with substantial certainty that a harmful or offensive contact would result. And right below that, as the proof, you write *Garrett Daily Starred. You briefly note the key fact, the kid pulling the chair, and why it proves that rule. Now that case isn't just a random story anymore. It has a purpose. It has a home in your mental blueprint. It is a weapon you can now use on an exam. When you get a fact pattern with a defendant who didn't mean to cause harm but was pretty sure it would happen, a light bulb goes off. Your brain doesn't just recall a story. It accesses a structured piece of your outline. It retrieves the rule, the case that proves it, and the analysis all at once. You do this for every single case in the course. You sort, you categorize, you synthesize. You argue with yourself about where a case should go. Does this case define the rule, or is it an exception to the rule? This struggle, this process of organization, is what burns the law into your mind. But you don't stop there. The A student adds one more layer: the nuance. This is the commentary, the why. Below the rule and the case, you add a section for policy. Why does this rule exist? What is the court trying to achieve? Is it about deterring bad behavior? Is it about compensating victims? Is it about economic efficiency? Your professor has been dropping hints about this all semester. This is where you capture that. You also add a section for the hypotheticals. Remember that crazy hypothetical the professor posed in class that tied everyone in knots? Write it down and explain the answer. These nuances are the tiebreakers. They show the professor you're not just a rule regurgitating robot. They show you are thinking like a lawyer, analyzing not just what the law is but why it is and where it might be going. You should start this process early. Don't wait until reading period. After you finish your first major topic in the syllabus, say after you finish all of intentional torts, spend that weekend outlining just that section. It's a rolling process. You build the house one room at a time. By the end of the semester, you'll have this incredible document, maybe 40 or 50 pages long. That is the entire course, structured and synthesized in a way that makes sense to you. Then you take it one step further. You condense. You take your 50-page master outline and you create a 10-page version, squeezing out everything but the most essential rules and case names. Then you take that 10-page version and you create a 1 or 2-page attack outline. This is your checklist for the exam. It's just the major headings and the key elements for each cause of action. By the time you've gone through this process of progressive condensation, you barely even need to look at it. You've internalized it. You've built the palace in your mind. You don't need the blueprint anymore because you know every single brick, every single wire, every single pipe by heart. This is what it means to be prepared. So you have your case briefing system down. You have your blueprint, your outline. You understand the law on paper, in the quiet of the library. But law school isn't just a paper exam. It's a performance. And the primary stage isn't the exam room. It's the classroom. It's that terrifying, unpredictable arena of the Socratic method. How do you handle being cold called? How do you turn that public fear into a private advantage? How do you use the classroom not as a place of judgment, but as your personal training ground to get smarter, faster, and sharper than everyone else? The answer lies in a fundamental misunderstanding of what that classroom and that Socratic professor are actually for. We're conditioned to see school as a place where we absorb information and then prove we've absorbed it on a test. The law school classroom isn't that. It's a dojo. It's a flight simulator. It's a sparring ring. The Socratic method isn't a tool for humiliation. It's a whetstone designed to sharpen your mind against the resistance of a complex problem, with a master craftsman, the professor, guiding the angle. Your fear of the cold call is completely rational. Public speaking is a top phobia. And this is public speaking combined with a high-stakes intellectual cross-examination you didn't ask for. Your heart pounds, your mouth goes dry. You feel the eyes of 100 of your smartest peers boring into you. But that fear is based on a false premise. The premise that you are supposed to have the right answer. Let me be crystal clear. There is often no single right answer. The point of the Socratic method is not to arrive at a destination. It is to explore the journey. The professor is testing your ability to think, not your ability to regurgitate. They want to see how you handle pressure, how you analyze a set of facts, how you apply a rule, how you distinguish one case from another, how you defend a position, and just as importantly, how you recognize the weaknesses in that position and adapt. This is the entire job of a lawyer, condensed into a terrifying 5-minute exchange. So, tip number 3 is this: weaponize the Socratic method. Don't just survive it, master it. Turn the professor from your antagonist into your personal trainer. And it starts long before you ever step into that classroom. When you're briefing your cases the night before, you can't just stop at the facts, the issue, and the holding. That's level 1. To weaponize the method, you have to do the professor's job for them. You have to start thinking in hypotheticals. After you've briefed the case, take a clean sheet of paper or a new document and ask yourself the questions you think they will ask. Let's say the case is about a self-driving car that malfunctions and causes an accident. You've briefed it. Now, you pre-game the Socratic dialogue. Ask yourself, okay, what if the owner had manually disabled a safety feature? Does that change the manufacturer's liability? What if the accident was caused by a software update that was pushed just seconds before? Who is liable then, the manufacturer or the software company? What is the policy reason for holding the manufacturer liable in the first place? Does it encourage safer products, or does it stifle innovation? How is this different from the 1920s case we read about the faulty wooden wheel on a Buick? You are literally creating a practice exam for the next day's class. You won't get every question, not even close. But the act of trying forces you to engage with the material on a completely different level. You move from being a passive reader to an active analyst. You start seeing the case not as a static story, but as a nexus of legal principles, a point on a much larger map. Now let's talk about the moment itself. The professor's eyes scan the room and they land on you. Your name is called. The spotlight hits. Here is your 4-step protocol for not just surviving but thriving. First, breathe. Seriously. Take one slow, deliberate breath. This isn't just fluffy advice. It physically counteracts the fight or flight response. It sends a signal to your brain that you are in control, not the panic. Second, listen to the exact question. Don't listen to the question you thought they were going to ask. Don't answer what your panic brain is screaming. Listen to the precise words. Is it a broad question about the facts? A narrow question about a specific line of the judge's reasoning? A policy question? The biggest mistake students make is answering a different question than the one that was asked. If you need to say, could you please repeat the question? There is zero shame in that. It shows you care about precision. Third, trust your prep. Open your case brief. This is not a closed book memory test. The professor expects you to use your notes. Find the relevant section. Anchor yourself in the work you already did. Start your answer with what you know for sure. Professor, the court in this case held that. Or the key facts the court focused on were. This builds your confidence and gets the ball rolling. Fourth, and this is the most important part, think out loud. If the professor asks you a tough hypothetical that you didn't prepare for, do not just sit there in silence while your brain cycles through 1,000 possibilities. Articulate your thought process. Say, well, my initial reaction is that the outcome would be different. On one hand, the principle from the original case seems to apply because of X. However, the new fact you introduced, that the driver was intoxicated, brings in principles of contributory negligence which might lead to Y. The tension I'm struggling with is whether the manufacturer's strict liability is superseded by the driver's recklessness. Do you see what just happened? You didn't give a perfect, polished answer. You gave something far more valuable. You showed the professor how you think. You identified the core legal conflict. You used legal terminology correctly. You demonstrated that you are grappling with the material in a sophisticated way. A professor will take a thoughtful, struggling, transparent answer over a slick, memorized, but shallow one every single time. This is the entire game. Let me tell you about a student I knew. We'll call him Ben. Ben was brilliant on paper but terrified of public speaking. His first cold call was a catastrophe. He was asked a simple question about the holding in Marbury v. Madison. He froze. Utter, complete, deer-in-the-headlights silence. After what felt like an eternity, the professor just said, "Okay, anyone else?" and moved on. Ben was mortified. He told me later he considered dropping out. Instead, he got angry. He decided he wouldn't let this beat him. He adopted the system I just described. For the next class on personal jurisdiction, he didn't just brief international shoe. He created a separate document of 20 potential Socratic questions. What if the contacts were purely online? What if the defendant was just visiting the state for a day? He gamed out every angle he could think of. A week later, his name was called again. The class went silent, remembering his first flameout. The professor hit him with a complex hypothetical. Ben took a breath. He looked at his notes, and then he started talking. He said, "Professor, that's a great question because it gets right to the tension between specific and general jurisdiction." He laid out one side of the argument. Then he said, "But the counterargument, which I think is stronger, is..." He wasn't perfect. He hemmed and hawed a couple of times, but he was engaged. He was thinking. He was a lawyer in training right there before everyone's eyes. When he finished, the professor didn't say "good job." He just gave a slight, almost imperceptible nod and said, "Okay, Mr. Davis. Good. Now what if we change the facts this way?" He had passed the test. He had proven he could think on his feet. He turned his greatest fear into his most formidable weapon. And here's the final piece of the puzzle. Your learning doesn't stop when the professor moves on from you. In fact, it's just beginning. After you're done, you aren't off the hook. You are now a spectator with a front row seat. Listen to how other students answer. Listen to how the professor pushes them. Every single exchange in that room is a free lesson. You should be mentally answering every question asked of every other student. When someone else gets stuck, figure out in your own mind how you would have gotten unstuck. The classroom becomes a 3-hour, high-intensity mental workout, and it costs you nothing extra. You are leveraging the intellectual horsepower of 100 other brilliant people and a legal expert for your own benefit. By doing this, you reframe the entire experience. The cold call is no longer a moment of judgment. It's a rep. It's practice. Getting it wrong isn't failure. It's data. It shows you where the gaps in your understanding are, and it shows you before the final exam when it actually counts. You are using the classroom as your personal laboratory to build the skills and the knowledge you will need when the stakes are real. So you've mastered the case brief, turning raw information into structured knowledge. You've conquered the Socratic method, turning public fear into your private training ground. You're winning the daily battles. But law school isn't won in a day. It's a marathon. All these individual cases, these individual classroom discussions, they're just trees. How do you see the forest? How do you connect all these disparate dots into a coherent, unified whole that you can actually use to solve a problem on a final exam? How do you build the master blueprint for the entire course? The answer is, you become the architect. You draft the blueprint yourself. This brings us to the single most important, non-negotiable, mission-critical skill you will learn in law school. This is tip number 3, forge the master outline. I want you to listen to me very carefully. If you only take one piece of advice from this entire video, let it be this. The creation of a master outline is not just a study technique. It is the entire game. It is the crucible where raw information, cases, statutes, lecture notes, is smelted down and forged into a weapon you will wield on your final exam. Every other tip we discuss is in service to this one. Case briefing gives you the raw materials. The Socratic method tests the purity of those materials. But the outline is the finished product. It is the synthesis of the entire course into a single, coherent, and usable document. So what is it? And what isn't it? A master outline is not a collection of your case briefs stapled together. It is not a rambling 200-page summary of every reading you did. That's just a less convenient textbook. A true master outline is the logical structure of the law itself, stripped down to its bare essentials. It is the black-letter law. It's the rulebook for the course. Think about it this way. The case method teaches you law through stories. The professor gives you Pearson v. Post, a story about two guys fighting over a dead fox, to teach you a single rule about the possession of wild animals. The casebook is filled with hundreds of these stories. By design, it's an inefficient, roundabout way to learn. They don't just give you the rulebook. They make you extract the rules from the stories one by one. The exam, however, does the exact opposite. The exam gives you a new story, the fact pattern, and asks you to apply the rules you were supposed to have extracted. Do you see the disconnect? You learn by going from story to rule. You are tested by going from a new story back to the rule. The outline is the bridge that spans this gap. It's the document where you reverse engineer the course. You take all those stories, all those cases, and you pull out the clean, simple rule from each one. And this is the magic, you organize those rules into a logical, hierarchical structure. You turn the chaotic narrative of the casebook into a ruthlessly efficient legal checklist. Let me give you a concrete example from torts. Your casebook might have a chapter on intent. You'll read a case about a 5-year-old pulling a chair out from under an old woman. Then you'll read a case about a mentally ill person who thinks he's Batman and attacks someone. Then a case about a prank gone wrong. It's a jumble of stories. In your outline, this becomes brutally simple. It would look something like this. Roman numeral 1, intentional torts. Capital A, battery. Number 1, elements of battery. Little a, an act by the defendant. Little b, intent. And under intent, you'd write the rule. Intent is satisfied if the defendant acts with the purpose of causing the contact, or acts with substantial certainty that the contact will occur. Then you'd have a little subpoint. I. Garrett Vidali. A 5-year-old can form intent if he knows with substantial certainty that pulling a chair will cause a person to hit the ground. See the difference? We went from a 10-page story to a single sentence that both states the rule and gives you the perfect example to remember it. You do this for every single topic in the course. You build the entire legal framework brick by brick. So how do you actually build this thing? First, don't start on day 1. You need some context first. Wait until about week 3 or 4. After you've completed your first major topic. Your syllabus is your best friend here. The professor has already given you the skeleton of your outline. The main topics on the syllabus should be your main Roman numerals. Every single weekend you should dedicate 2 to 3 hours to outlining. Don't wait until reading period. If you wait until the end of the semester, you will be crushed by the sheer volume of information. The goal is to synthesize the material from that week while it's still fresh. Take your case briefs, take your class notes and distill them. Ask yourself, what was the point of this week? What were the 1, 2, or 3 main rules I learned? Find their logical place in your outline and write them down. Your outline should have 4 key ingredients for every major rule. First, the black letter law. The rule itself stated as clearly and concisely as possible. Put it in bold. This is the core. Second, the case illustration. A 1-sentence summary of the key case that demonstrates that rule. Not a full brief, just a trigger. E.g. Paul's graph, the unforeseeable plaintiff. That's it. It's a mental anchor. Third, the policy. Why does this rule exist? What is the court or legislature trying to accomplish? Is it about economic efficiency, fairness, deterrence? Professors adore policy arguments. Sprinkling in a sentence or two about policy is how you go from a B+ to an A. Fourth, the professor's hypoge. Remember that weird hypothetical your professor posed in class about a 2-headed turtle that signs a contract? Write it down in your outline next to the relevant rule. Those hypoges are windows into your professor's mind. They are often simplified versions of what will be on the final exam. Now, a critical warning. You will be tempted to take a shortcut. You will find outlines from upperclassmen. You will find commercial outlines from companies like Barbary or Quimby. It is perfectly fine to use these as a reference to check your work or to understand a topic you're struggling with. But you must not, under any circumstances, use someone else's outline as your own. Let me be clear. The learning is not in having the outline. The learning is in the process of creating it. The act of wrestling with the material, of deciding what's important and what's not, of rephrasing a complex judicial opinion into a simple rule, that is the act of learning the law. It's like exercise. Watching someone else lift weights won't make you stronger. You have to struggle with the weight yourself. Creating your outline is the mental weightlifting of law school. Don't cheat yourself out of the workout. I remember my first semester torts exam. I walked in with my 42-page outline. It was a work of art. I had spent every Sunday refining it. It was color-coded, tabbed, with attack plans for negligence and flowcharts for causation. I knew it backward and forward because I had built it from scratch. I saw a guy a few rows over from me. He had a 300-page commercial outline he'd probably bought the week before. The proctor said, "Begin," and I watched him. He spent the first 20 minutes of a 3-hour exam frantically flipping through his binder, his eyes wide with panic, just trying to find the right section. He was lost in a stranger's map. My outline wasn't a map. It was an extension of my own brain. I didn't need to search for the rules. I knew where they were because I had put them there. Your outline is your personal Bible for the course. It should be concise. If your outline for a single course is over 50 or 60 pages, you're doing it wrong. You're including too much detail. You're writing a book, not a blueprint. The goal is synthesis, not transcription. You have to make ruthless choices about what matters. And in making those choices, you master the material. This document is the physical manifestation of your understanding of the law. It transforms the fog of the Socratic classroom into a clear, logical structure you can deploy under pressure. It's the most powerful tool in your arsenal. It is the master key that unlocks the entire course. But having the perfect blueprint, the perfect weapon, is only half the battle. A soldier can have the finest rifle in the world, but if they've never fired it under pressure, if they've never been in a simulation, they will freeze in actual combat. How do you pressure test your knowledge? How do you simulate the stress and confusion of a real law school exam so that when the day comes, you're not just prepared, you're battle-hardened? The answer is deceptively simple, yet it's the single biggest differentiator between the students who merely survive law school and those who dominate it. You simulate the exam by taking the exam over and over and over again, not just reading old questions, not just thinking about how you'd answer. I mean sitting down in a quiet room with a timer ticking ominously in front of you and forcing your brain to bleed onto the page for 3 solid hours. This isn't just a study technique. This is the crucible. This is where knowledge is forged into skill. Think about it. A pilot spends hundreds of hours in a flight simulator before they ever carry a single passenger. They don't just read the manual for the Boeing 747. They are put into a machine that mimics the terrifying shudder of engine failure, the disorienting chaos of a storm, the split-second decision-making required when the landing gear won't deploy. They experience the panic, the adrenaline dump, the mental fog of a crisis in a safe environment so that when it happens at 30,000 feet, their training, their muscle memory takes over. Your law school exam is your engine failure. The convoluted, 10-page fact pattern is your storm. The ticking clock is the ground rushing up to meet you. And your practice exams? They are your flight simulator. So, how do we build this simulator? First, you need ordnance. You need practice exams. Your number one source is your professor. They almost always make past exams available through the library or online. These are pure gold. They are a direct look into the mind of the person who will be grading you. You will see their pet issues, the way they structure questions, the level of detail they expect. If you do nothing else, do every single old exam your professor provides. Second, you have commercial supplements. Books like Examples and Explanations or the Q&A series are fantastic. They provide hypotheticals and model answers. Third, your casebook itself often has problems or hypotheticals at the end of chapters. Most students skip these. Don't be most students. Once you have your materials, you must create the simulation environment. This is non-negotiable. Find a place where you will not be disturbed for the full duration of the practice exam, whether it's 1 hour or 4. The library is perfect. Turn your phone off. Not on silent. Off. And put it in your bag out of sight. Close every tab on your computer except your word processor. If it's a closed book exam, put all your notes, outlines, and books on the other side of the room. Your brain needs to feel the scarcity of resources. It needs to learn that it cannot simply Google the answer or flip to the right page in the outline. It has to rely on itself. Then you set the timer. And you honor it. This is the most critical element. The time pressure is what separates legal knowledge from legal analysis. Anyone can write a perfect answer with unlimited time. A lawyer doesn't have unlimited time. A law student doesn't have unlimited time. When you start that clock, you are training your brain to perform under duress. The first time you do this, you will panic. You'll read the first paragraph of a fact pattern, and your mind will go completely blank. You'll see a dozen potential issues and have no idea where to start. Your heart will pound. You might even feel the urge to just quit, to close the laptop and walk away. Good. That is the simulation working. That is the feeling of combat. Your job is to stay in the fight. Force yourself to start writing. Use the IRAC or CRAC framework we've discussed. Issue, rule, analysis, conclusion. It is your rifle, your standard operating procedure in the chaos. The first practice exam you write will be a disaster. It will be disorganized. You'll miss major issues. You'll run out of time halfway through the second question. And when you finally read the model answer, you will feel a crushing sense of inadequacy. Excellent. This is the entire point. That feeling of failure is the greatest teacher you will ever have. Every issue you missed on that practice test is an issue you will never miss again. Every poorly structured argument is a lesson in clarity for the next attempt. You have just exposed a weakness in a controlled environment. You found the flaw in your armor during a training exercise, not during the actual battle. You now have the opportunity to patch it, to reinforce it, to make it stronger. After you've taken the exam and reviewed the model answer, your work is not done. You must now debrief. This is where you take your messy, flawed, time-pressured answer and you methodically compare it to the Platonic ideal of the model answer. Don't just look at what you got wrong. Ask why you got it wrong. Did you not know the rule? That's a knowledge gap. Go back to your outline. Did you know the rule but failed to see how it applied to that specific fact? That's an analytical gap. You need to practice connecting facts to law. Did you see the issue but run out of time before you could write about it? That's a time management problem. You need to practice outlining your answer more quickly and writing more concisely. This process of pressure testing, failing, and debriefing is transformative. But you can take it to an even higher level. You can move from the flight simulator to a live fire exercise. You do this by weaponizing your study group. Most study groups are useless. They are social clubs that devolve into complaining about the reading or gossiping. A high-impact study group is a sparring team. Here's how you run one. You and 2 or 3 other serious students agree to all take the same practice exam separately under timed conditions. Then you meet. But you don't just go over the answer. You defend your answer. You attack theirs. Person A says, I thought the main issue here was battery. Person B says, I disagree. I don't think the element of intent was met because of this specific fact on page 2. The stronger claim is negligence. Then you argue. You pull out the case law. You dissect the fact pattern. You become an advocate for your position. This adversarial process is the closest you can get to the Socratic method and the practice of law without being in a courtroom. It forces you to not only see your own argument, but to anticipate and dismantle the counterarguments. It reveals ambiguities in the law, and the facts that you would never see on your own. Arguing with your peers, forcing each other to justify every single analytical leap, sharpens your reasoning like nothing else. It turns the dull iron of passive knowledge into the sharpened steel of a legal argument. Finally, the ultimate pressure test. Office hours. But not the way most students use them. Don't go to your professor and ask, can you explain adverse possession? That's a waste of their time and yours. That's what the textbook is for. Instead, you go in after you and your sparring team have battled over a practice exam. You walk in and say, Professor, my group and I worked through your 2018 exam. We had a major disagreement on question 2. I argued for this interpretation of the facts, citing Pearson v. Post. My colleague argued for another, citing a different policy consideration. Can you walk us through how you would analyze that specific tension? Do you see the difference? You're no longer a student asking for a lecture. You are a junior colleague presenting a complex problem and asking for a senior partner's guidance. You are demonstrating deep engagement, critical thinking, and a commitment to mastering the material. You are not asking to be spoon-fed. You are asking for a critique of your own hard-won analysis. This is how you build a reputation with your professors. This is how you truly learn. So forget the comfortable illusion of highlighting a textbook. Forget the passive act of rereading your notes. That's reconnaissance. That's studying the map. The war is won in the trenches of timed practice exams, in the sparring sessions of a dedicated study group, and in the high-level debriefings with your professor. You must actively seek out the pressure, the confusion, and the failure of the simulation. Because only by facing the enemy in training day after day, will you develop the instincts, the resilience, and the unshakable confidence to perform when the lights are on and everything is on the line. And when that moment comes, you will not be standing there alone. This is the final and perhaps most misunderstood piece of the puzzle. It's the one that separates the lone wolves who burn out from the pack leaders who conquer. We have been talking about individual discipline, about personal systems, about the war that happens inside your own mind. But the greatest warriors in history, the most successful teams, the most innovative companies, they all understood a fundamental truth. True strength is forged in alliance. This brings us to our fifth and final principle. You must assemble your intellectual fire team. Now, when I say study group, I need you to take whatever preconceived notion you have of that phrase and throw it out the window. I am not talking about a casual get-together in the library where you sip lattes, compare notes, and complain about the professor. That is not a study group. That is a commiseration committee. It is a therapy session that gives you the illusion of productivity, while actively draining your time and reinforcing your anxieties. The typical law school study group is a disaster. It's a place where the unprepared come to leech off the prepared. It's where one person, the one who actually did the reading, ends up teaching everyone else for free, getting nothing in return. It's a disorganized, rudderless conversation that drifts from contract formation to weekend plans without ever achieving a single, concrete objective. This kind of group is worse than studying alone. It is a slow-acting poison that will kill your grades and your confidence. What I am talking about is something else entirely. I'm talking about a small, elite, disciplined unit. A team of 2, 3, maybe 4 people at the absolute maximum, bound by a single ruthless purpose, to make each other intellectually invincible. This isn't a social club. Your best friend might be the worst possible person for this team. You are not looking for friends. You are looking for operators. You are looking for people who are as hungry, as disciplined, and as committed to excellence as you are. You are looking for people who will challenge you, who will call you out when you're wrong, who will push you past your breaking point because they know that's where growth happens. This is your sparring circle. This is your brain trust. This is the forge where your understanding of the law is hammered into a weapon. So how do you build this elite unit? First, the selection process is critical. You must be a talent scout. Watch people in class. Who asks the sharpest questions? Who isn't afraid to be wrong? Who demonstrates a work ethic that matches your own? Don't look for the person with the highest grades. Look for the person with the sharpest mind and the most tenacious spirit. Look for diversity of thought. If you're a big-picture thinker, find someone who is relentlessly detail-oriented. If you're brilliant at issue spotting, find someone who is a master of rule synthesis. Your team should be a collection of strengths that cover each other's weaknesses. Once you have your team, you establish the rules of engagement. This is a non-negotiable contract. Rule number 1. Everyone comes prepared. Always. Coming to a meeting unprepared is the ultimate sign of disrespect to the team and its mission. It is grounds for immediate dismissal. There are no passengers in this unit. Everyone pulls their weight. Rule number 2. Every meeting has a clear written agenda, circulated 24 hours in advance. For example, Tuesday from 6 to 8 p.m. First hour, we dissect the concept of proximate cause in torts. Second hour, we wargame 3 new hypotheticals on negligence. No deviations. No small talk. You arrive on time, you execute the mission, you leave. Efficiency is your religion. But the most important rule, the core principle that makes this entire system work, is this. The primary purpose of the group is not to share information, but to pressure test it. The goal is not to get the answer. It's to destroy every possible wrong answer. This is where you weaponize the Feynman technique on a group level. Your mission is to teach, to question, and to defend. Here's how it works in practice. You implement a system called the hot seat. Each meeting, one member is in the hot seat for a specific topic. Let's say it's your turn, and the topic is the hearsay rule in evidence. Your job is to stand up in front of your 3 teammates and teach them the entire hearsay doctrine from scratch, as if they've never heard of it. You can't use your notes. You can't use your outline. You have only your own internalized understanding. You must explain the core rule, its purpose, and then walk them through every single one of the major exceptions. Present sense impression, excited utterance, state of mind, and so on. And while you are teaching, their job is not to passively listen. Their job is to be the most aggressive, skeptical cross-examiners you have ever faced. They interrupt you. They ask why. Why does that exception exist? What's the policy rationale? Give me an example where that applies. Now give me an example where it almost applies but doesn't, and explain the difference. They will hit you with a rapid-fire series of hypos. The victim screams, "My leg is broken," as the car hits him. Is that an excited utterance or a present sense impression? Argue both sides. They will intentionally misstate the rule to see if you catch it. So you're saying any statement made to a doctor is a valid exception? Your job is to stand your ground, to defend your position, to articulate the law with precision and clarity under immense pressure. It will be brutal. It will be uncomfortable. You will feel exposed. You will find the gaps in your knowledge torn wide open for everyone to see. And it will be the single most effective learning experience of your law school career. Because in that moment, you are no longer passively reviewing material. You are actively creating and defending knowledge. The act of verbalizing a complex idea, of parrying counter-arguments, of simplifying the intricate for a skeptical audience, that is what burns the information into your neural pathways. You will walk out of that session with a command of the hearsay rule that is 1,000 times stronger than what you could ever get from just reading a book or staring at an outline. Then you rotate. Next session, it's someone else's turn in the hot seat with a different topic. Everyone gets their turn to be the teacher, and everyone gets their turn to be the inquisitor. Beyond the hot seat, your team's other primary function is to become a hypothetical generating machine. You're not just answering the hypos your professor gives you, you are creating your own. You learn to think like the examiner. Each of you comes to the meeting with one or two complex, multi-issue hypotheticals you've written yourself. You put them on the whiteboard and you solve them as a team, arguing over every single element. Is that really a battery? Or is it just an offensive touching? Did he actually have the requisite intent for that crime? Or was it just recklessness? Let's argue it out. This process does more than just teach you the law. It teaches you the art of legal analysis. It trains your brain to see the patterns, to spot the hidden issues, to make the nuanced arguments that separate the A+ answers from the B- ones. This is the path. You transform the dreaded study group from a liability into your single greatest strategic asset. You build a culture of accountability, of rigorous intellectual combat, of mutual support. This team becomes your anchor in the storm of law school. When you're feeling overwhelmed, they are there to remind you of the mission. When you're struggling with a concept, you have 3 other brilliant minds dedicated to helping you solve it. You share the burden, and in doing so, you multiply your strength. You are creating the very foundation of a professional legal network. A team you can trust, a team that makes you better. And you are simulating, in a safe environment, the high-stakes reality of legal practice, where you must constantly defend your ideas, collaborate with your peers, and deliver clarity under pressure. This brings us to our 5th and final tip, and I want you to listen closely because this is the one that holds all the others together. It's the one that most students ignore, and it is, without question, the single biggest reason why brilliant, capable people crash and burn before they ever get to wear the cap and gown. The final tip is this: you must treat law school as a marathon, not a sprint. You must fiercely protect your own mind. Think about it. We've just spent all this time talking about the intense intellectual combat of a study group, the pressure of cold calls, the mental gymnastics of outlining. It's a high-performance environment. And what do we know about high-performance individuals, whether they're elite athletes, surgeons, or special forces operators? They are masters of recovery. They understand that peak performance is not a result of endless, grinding work. It's a result of a disciplined cycle. Intense stress, followed by deliberate rest. Law school, however, sells you a different, more toxic myth. It's the myth of the grinder. The student who pulls all-nighters fueled by caffeine and sheer willpower. Who highlights until their fingers are stained yellow. Who sacrifices every relationship and hobby at the altar of their torts textbook. We see this person in movies, we hear about them in campus legends, and we think, that's the standard. That's what it takes to win. But it's a lie. It's a recipe for burnout. Let me tell you about a student I knew. Let's call her Jessica. Jessica was the perfect 1L on paper. She came from a top undergrad, had a stellar LSAT score. And her work ethic was legendary. In the first 2 months, she was a machine. She read every case 3 times, her briefs were immaculate. She never missed an office hour. She was the one everyone else looked at with a mixture of awe and intimidation. She was living the grinder myth. By November, the cracks started to show. She was tired. All the time. The kind of bone-deep exhaustion that coffee can't fix. She started getting headaches. She'd sit in the library, staring at a page in her contract's casebook, and realize she'd read the same paragraph 10 times without absorbing a single word. Her mind, once a sharp analytical tool, felt like it was wading through mud. The fear set in. She thought, I'm not smart enough for this. So what did she do? She doubled down. She cut out her weekly jog. She stopped calling her family. She started skipping meals to save time, grabbing a protein bar from a vending machine instead. She was sacrificing the very things that fueled her brain in a desperate attempt to force it to work harder. It's like trying to drive a car faster by refusing to stop for gas. It's not just ineffective, it's catastrophic. Her first semester grades came back and they were average. For Jessica, who had never been average at anything in her life, it was a devastating blow. She had sacrificed her health, her happiness, her entire sense of self for mediocrity. The second semester was even worse. The passion she once had for the law, the intellectual curiosity, was gone. It was replaced by a dull, persistent anxiety. She wasn't learning anymore. She was just surviving. Jessica didn't flunk out, but she graduated with a fraction of the potential she walked in with. Burnt out and disillusioned with a profession she hadn't even entered yet. Jessica's story isn't an exception. It is the rule for those who follow the grinder's path. The top-performing students, the ones who get on law review, who nail their interviews, who graduate with honors and go on to have fulfilling, impactful careers, are not the ones who study 24/7. They are the ones who understand that their mind is their single most important asset, and they protect it like a fortress. So how do you do that? It's not about studying less, it's about resting smarter. First, you must schedule your recovery with the same ruthless discipline you schedule your study time. Pull out your calendar right now. Before you block out time for property reading or civil procedure outlines, you block out 8 hours for sleep. Every night. Non-negotiable. This isn't a luxury. It's a biological necessity for memory consolidation and cognitive function. The all-nighter before an exam is the single most counterproductive ritual in legal education. You are literally destroying the memories you just spent weeks trying to build. Next, schedule at least 30 minutes of physical activity every single day. A brisk walk, a run, lifting weights, anything that gets your heart rate up. This isn't about fitness. It's about mental clarity. Exercise is proven to reduce stress, improve focus, and stimulate the growth of new brain cells. Think of it as maintenance for your cognitive engine. Finally, you must schedule one block of time each week, at least 3 to 4 hours, where you are not allowed to be a law student. No reading, no thinking about cases, no talking about outlines. During this time, you must do something that engages a different part of your brain. Play a musical instrument, go hiking, visit a museum, have a long dinner with friends who aren't in law school. This is your identity protection time. It reminds you that law student is a role you are playing, not the entirety of who you are. This perspective is what will save you when you get a bad grade or have a rough cold call. It detaches your self-worth from your academic performance, which is absolutely crucial for long-term resilience. Your classmates will tell you this is a waste of time. Your own anxiety will scream at you that you should be in the library. You must learn to see that voice for what it is, the siren song of burnout. The truly successful student isn't the one who can grind the longest. It's the one who can show up, day after day, month after month, with a mind that is sharp, rested, and ready to engage. That is not an accident. It is a strategy. And that's what this all comes down to. Strategy. Let's pull back and look at the 5 principles we've covered. We started by transforming how you read, moving from a passive student collecting facts to an active analyst hunting for the argument, the why behind the what. Then we revolutionized your case briefing, turning it from a tedious summary into a strategic weapon, a one-page arsenal designed for the specific battleground of your final exam. From there, we tackled the beast of outlining, shifting your focus from simply organizing information to actively synthesizing it, forcing you to create your own intellectual framework of the law, a mental palace that you and only you could build and navigate. We then entered the arena of the classroom and the study group, learning not just to survive the Socratic method, but to master it by simulating its pressures, turning passive knowledge into active, defensible arguments, and learning the collaborative art of sharpening your ideas against the minds of your peers. And finally, we put a protective wall around all of it, recognizing that the brilliant mind you're working so hard to build can only function if it's cared for. We committed to the marathon, not the sprint, understanding that rest and recovery are not signs of weakness, but the essential tools of peak performance. Do you see the thread that connects all of these? None of them are about being born smarter. None of them are about having a photographic memory. And none of them are about sacrificing your entire life. They are about being strategic. They are about being intentional. They are about working with the grain of how your brain actually learns, retains, and performs under pressure, rather than fighting against it. Law school is a transformative experience. It is designed to be hard. It will break down the way you think and rebuild it from the ground up. You will be challenged in ways you can't yet imagine. But it is not a mysterious black box where success is determined by some innate genius. It is a system. It is a game with rules. And the tips we've discussed are the keys to mastering that game. You are embarking on one of the most intellectually demanding journeys a person can undertake. But you are also preparing for a profession of immense consequence. You are learning to be the person someone calls on the worst day of their life. You are learning to be a guardian of rights, a voice for the voiceless, an architect of a more just society. The challenge is worthy of your best effort. But your best effort is not your most exhausted effort. It is not your most stressed out, sleep-deprived effort. Your best effort is your sharpest, most focused, most resilient, and most strategic self. So take these tools. Use them. Adapt them. Make them your own. Don't just survive law school. Master it. Because the world doesn't just need more lawyers. It needs clear thinking, resilient, and deeply capable advocates. And that is exactly what you are here to become. Now go make it happen.